I'm attorney Phil Giacino, and this is WLINY's Finding Common Ground here on Altice. Got a great show planned for tonight. You can see this show every Saturday at 10 a.m. on channel 115, and also Thursday mornings, 1 a.m. for you insomniacs, at 1 a.m. channel 20. Also, you can see Finding Common Ground, a little more politics added, and that can be seen on Friday nights at 8 p.m. Eastern Standard Time. Let's get to it. Tonight we got a fun show planned. I want to talk about the anatomy of a criminal jury trial, the strategy behind it, how it's selected, who gets to decide if a jury is impaneled in a criminal case, and also a couple of interesting things that happened during some of my criminal trials, and also a case that just came out of Michigan where a criminal defendant was convicted by a jury, and one of the jurors turned out to be his wife's marriage counselor, also had dealt with him, but neither one, they say, neither one realized that until after the trial. So we're going to talk a little bit about that. Here in New York, and I'm going to focus in on New York, and that other case came from Michigan, but I'm an attorney here in New York, so we're going to talk New York law. In a criminal case, a criminal defendant has the right, the constitutional right, to decide if he wants to have a jury trial or not. If it's a felony or a misdemeanor. If he's charged with a violation of law, harassment, disorderly conduct, he can still get a trial, but it will not be a jury trial. So felonies are the more serious, punishable by more than a year in jail, or a misdemeanor, punishable by up to a year in jail. You get a jury trial if the defendant wants it. The prosecutor does not have a say in the matter. I'm a former prosecutor. I was an assistant DA here in Suffolk County from 89-91. And when I did criminal jury trials, I did about 12 to 14 during my short stint in the DA's office. I didn't have the say as to whether or not a jury would be selected. Sometimes I wanted it, sometimes I didn't, but it wasn't up to me to decide. The defendant and his attorney would decide if they wanted a jury. Once that decision was made, they would have to impanel the jury. How do they do that? The judge, and it's different in criminal cases compared to civil cases, like in car accident cases. In a criminal case, the judge is involved in every aspect of selecting the jury. In a civil case, that's not the case. The two attorneys, or however many there are, pick the jury panel and then go to the judge and say, we have a panel. If questions come up, they have to go see a judge. In a criminal case, the judge runs the jury selection process. So once the decision is made to have a jury, the judge will say, okay, on Tuesday morning, we're going to pick the jury. So the defendant has to be there. The defense attorney's there. The prosecutor's there. The witnesses are not there. Right? The panel is usually about 40 to 50 people, depending if it's a misdemeanor or felony, but about 50 people. So they bring in the panel from the jury room, and they put them in the back of the courtroom. And the judge will just do some preliminary, what the case is about a little bit, how long it might be. The reason why they want to do that is because let's say the trial is going to be 2 weeks, and you have somebody that's a prospective juror that is pregnant and is going to give birth in a week, or somebody that's going to have surgery, or somebody that's going to Hawaii. The judge has to know that, because you don't want to pick somebody that in the middle of the trial is going to put their hand up and say, I got to leave. So they ask those questions and they weed some of the jurors out. So it might be 50, maybe you're left with 40. They all have a questionnaire that they have filled out. So now you're down to the 40 that, let's say, can serve. Sometimes there's an issue. One jury might say, I'm hearing impaired, I really can't sit. So the decision is made to let that juror go. So then let's say you're down to 40. They have something that looks like a bingo wheel. And they put all the names in there and they start calling the names out. You know, Sally Jones, and Sally Jones takes a seat. They seat about 10 to 12 people, sometimes a little more than that. And this is save time, because ultimately in a misdemeanor, it's only going to be 6 and generally 1 or 2 alternates. In a felony, it's going to be 12 and some alternates. So let's just say it's a misdemeanor trial. They're going to probably have about 10 to 12 people in that box, they call the jury box. And then the attorneys get to question the jurors. First, the prosecutor goes, says, hi, my name is so-and-so. I will be prosecuting this case. I'm from the DA's office, and can say a few words and then gets right to it. Looks at the questionnaire that was filled out, and from that can pick questions, or not. They could put that aside. For instance, let's say you see a questionnaire where the person says that they've been the victim of a crime. The prosecutor might say, what crime were you the victim of? Was the case resolved? Do you have any animosity toward the prosecutor? Because let's say the case went to trial and the person was found not guilty. The person might be ticked off at the DA's office and might hold it, maybe or maybe not, but might hold it against the prosecutor prosecuting the case. Or the defense attorney, because the defense attorney was mean to them. So let's say that person testified at the criminal trial and the defense attorney really went at him. They might not like the defense attorney and hold it against all defense attorneys. So these are the things that get fleshed out by the questioning of the jurors. So when they're both done, each is given a certain amount of time, let's say 15 minutes. They each go. When they're done, the judge will call the attorneys into the room, in chambers or another room, and they will go through the process of deciding out of those 15 or 12 or whatever, how many will be selected as actual jurors. Now, each case is different. Let's say a typical misdemeanor, the attorneys may have 3 what they call peremptory challenges. Peremptory challenges. That means that they can get rid of somebody for just about any reason whatsoever. I don't like that guy, or I don't like that lady. I don't trust their answers. I don't think they're going to help my client out. And of course, my focus is different than the DA's focus. The DA might want somebody that's law and order, that maybe is, a juror that might say guilty because they're law and order. They might want to find somebody guilty, whereas you might have somebody that's like a hippie or somebody that's very liberal that might want to say, no, I can't find somebody guilty, or there might be a reason why they did that crime. You don't want somebody like that. So the good thing about it is the process ends up with people that maybe the defense attorney is not overly happy with, or that the prosecutor is not overly happy with, but some people in the middle. That's probably more fair. Because if it's somebody that I really want, the prosecutor is not going to want that person, and vice versa. So you have 3 peremptory, and you have to keep that in mind. Because if you get rid of the first 3, 4, 5, and 6 might be worse, and you're stuck, except for what they call challenges for cause. A challenge for cause is when, let's say a defense attorney says, that juror, when I questioned him, said he could not be fair and impartial because his brother was a victim of a similar crime and he can't be fair and impartial. Or his father's a cop and he always believes when cops testify, or he hates cops, whatever the case might be. That defense attorney can use what they call a challenge for cause. When you do a challenge for cause, if you're successful, that juror, potential juror, is removed, and you don't waste a peremptory challenge. I've had cases where I was able to get 4 or 5 people off the panel because for cause. They said, oh, I don't think a cop would lie, and I know a cop's going to testify. Now, when we go in the back and I say, I want that for cause, the defense attorney might disagree with me and say, no, yeah, he did say that he couldn't be fair and impartial, but upon further questioning, he said he could be. The judge makes that decision. It's discretionary. So the judge could say for cause or not for cause. Now, if it's not for cause, you have to decide. You only get 3 peremptory. So if you use them too soon, you lose out. And then you're stuck with what might be a worse potential juror. So you have to do it strategically. Once they impanel the jury, the judge will read to them certain legal principles, beyond a reasonable doubt, things like that. Not the law yet. That comes at the end, but some legal principles they discuss. And the jury then is impaneled, 6 and 2 potential jurors. If you don't get 6 and 2 from that 15, because let's say I use my 3 peremptory, the DA uses his or her 3 peremptory, and there are challenges for cause, we may have to put more people in the box. So let's say juror 1, I didn't remove, the DA didn't remove. That juror 1 is juror 1. Let's say 2, 3, and 4 were removed. 5, 6, and 7 weren't, 5, 6, and 7 become 2, 3, and 4. So let's say we exhaust the panel of the people put in the box the first time around, we go to the second round, and maybe a third round, depends. Certain cases are more difficult to pick a jury than in other cases. If you have, let's say, an assault case, it might not be as difficult as a rape case or a sexual assault case. I've done those kinds of cases. You lose a lot of people that were victim of crimes, sex abuse. And then they don't discuss that in front of the other potential jurors. We go in chambers and the person might say, I can't sit. I was a victim of a sex abuse when I was younger, or somehow that affects them. So a lot of times we let that person go. And I've had cases like that, sex abuse, rape, that took 2 or more days to pick the jury. You usually don't see that in more run-of-the-mill, like a DWI. You don't really see that because people go, yeah, I could sit for a DWI, no big deal. Oh, it's a rape case, I don't know about that. So those cases take longer to pick the jury, and you got to be very, very careful because you don't want someone sitting there that really doesn't have the emotional makeup, for whatever reason, to sit for that kind of case. A DWI, even an assault, that's different. Now, when I first started out, I said it's the defense attorney and the defendant that decides if there's going to be a jury. There's a whole strategy behind that. Now, why would a defense attorney and defendant want to go with a judge? Well, let's say, and in those kinds of cases, the judge has the case from the beginning. So there could be a bunch of conferences that the judge said things about the case. Unlike a civil case, like I said, where you don't get the judge until the end of the jury selection process. So let's say I'm the defense attorney, and we've had some conferences, and the judge is saying, what are we doing here? This case is nonsense, or I think it's a weak case. I might not want a jury. I might say, I want to go with that judge. I think I got a better shot with that judge than a jury. You see a lot of bench trials when it involves the police, because the defense attorney feels that he might get a fairer shake with the judge than with a panel of 6 or 12 people that might be more inclined to convict the cop. So it's a strategy. I generally go with a jury. I don't remember the last time I went with a jury when I had that I didn't go with a jury when I had the option. Now, I've tried violation cases, disorderly conduct, things like that, where I had no choice. It's a bench trial. But with a jury, I always feel that it's better, I like the odds better of the prosecutor having to convince 6 people or 12 people from all different walks of life than the judge. Because if it's a bench trial, all the DA has to do is convince that judge. Also, I may have a client with some bad background. That may not come up in a jury trial. Right? There's certain rules that apply. It could prejudice the jury. Is it the same kind of crime? Does it go to his, like in other words, let's say a person has a prior larceny or something that has to go with truthfulness. That may come out. If he has a prior DWI and it's a DWI trial, that's not coming out. Unless the defendant is stupid enough and opens the door. Like if he says, I've never been in trouble before, that opens the door to the prosecutor to come in. You've never been in trouble before? Well, what about that 2015 DWI? So I usually go with a jury, and I've had a lot of success doing that. Going with a bench is risky if you don't, unless you know that the judge might be leaning toward your case. And a very interesting, kind of funny situation when I first started out as a prosecutor, it must have been around 1989-90. One of my first jury cases was in Hauppauge, the Dennison building, and it was a DWI. And on the in the jury panel was a high school teacher of mine. I won't give the name, but he taught health. And don't forget, they say, does anybody here know the defendant, the prosecutor? He didn't answer up. And I'm looking at him, and it wasn't that far removed. Don't forget, I must have been maybe 25, so I was in high school at 17. So it wasn't like 30 years ago, like it would be now, or more. And I'm looking at the guy, and I'm like, say something, you know me. He didn't say anything. So I said, this was a cranky judge. And I said, Judge, no, Mr. Giacino, we got to follow the procedure. Wait to see if that person is in the panel. So they do the bingo wheel, and his name is picked. So he's in that 10 to 15 group box. of potential jurors. And I'm still looking at him like, you don't know me? I look kind of the same. Didn't say anything. So I said, Judge, sidebar please. So the judge begrudgingly said, all right, come over here. So I go over there, the defense attorney, I was the prosecutor, defense attorney, and the judge. And he says, what is it, Mr. Giacino? And I said, I know one of the jurors in the box. And he said, well, he didn't answer up. Maybe you don't know him. I said, you said the name, Mr. So-and-so. I said, I know him. So the judge looks at me like puzzled. And he said, all right, wait a second. So then they call over. Don't forget, they don't do it in front of the jury. So they call him over to the side. Sometimes you go in a different room. And he said, sir, do you know Mr. Giacino? And his response was, oh yeah, that's right. That's Phil Giacino. I know him. He went to Smithtown West. And he was in one of my classes. Judge is like, you're excused. So I'm thinking, what was that all about? So later, there was a break in the action. He was still hanging around. And I got this, I saw him. And I went up to him and I said, you saw me. What was that all about? He says, well, I thought it was you, but I really wanted to sit as a juror. I said, but that's not permitted if you know me. And he knew me. It wasn't like he passed me by in the mall one time. He was my teacher. He was removed from the panel, and he should have been. There was an interesting case that just came out, Michigan Court of Appeals. This man was convicted of assault after a jury trial. At the end of the jury trial, he realized that one of the jurors that convicted him was his wife's marriage counselor when they were going through a divorce. It was more his counselor, her counselor rather than his. But he sat in on a couple of sessions, and he even said it got contentious. There was cursing, profanities were used. So he said, that marriage counselor might think I'm a nut. He sat as a juror. He convicted me. I want a new trial. So they looked into it. Apparently, the counselor said he remembered the woman, the wife. He didn't remember him. Now, whether that's true or not, I don't know. It should have been court before. If it was court before, that guy would have never sat on that jury. It would have been a big conflict of interest. But the trial took place. There was a conviction. The Michigan Court of Appeals said that there was no evidence that the counselor lacked impartiality as a juror. Because he said, I didn't even remember the guy, and he told the judge he acted fairly as a juror. Now again, I don't know if he did or not. The Michigan court said, you know what? It wasn't court before the trial. There's no evidence that he was, like, I'll give you an example. Let's say during the trial, this guy said, oh, that defendant is crazy. I was the marriage counselor, and he said blah, blah, blah. Then the trial would have been, the conviction would have been vacated, and he would have got a new trial. But there was no evidence that this man did that. So that's a perfect example of, the guy shouldn't have been a juror in the first place. But because nobody caught it, there was no evidence that he wasn't fair and impartial. The conviction stood. Now, this was an assault. Could it have been different if it was a capital offense case, a murder case where the guy's looking at 25 years? I suspect it could have been. Where they try to be a little more careful. But it stood. I'll give you another funny story, jury trial. I once had a jury trial probably about 3 years ago. And in the middle of the trial, I'm questioning the complaining witness. I'm the defense attorney, and I'm questioning the person that made the allegation against my client. And there was a break, and the DA comes up to me and says, Phil, the complaining witness has said that you were his attorney at one point. And I said, I don't even know who the guy is. The name doesn't ring a bell. I don't know who it is. So the judge was notified, wasn't too happy about it, that at this late stage. And the judge said, you know, what do you have? So she said, we don't really have anything. He just said that Mr. Giacino was his attorney previously. I said, I have no recollection. What kind of case was it? So during the break, I ran downstairs, and he had been charged with a crime years ago. And my law firm, not the firm I have now, but an older law firm that I used to be with right out of the DA's office, represented him like 24 years ago at that time. 24 years ago. I had gone in to court one time for him. I wasn't the attorney really handling the case, but I did appear with him one time for a conference. I don't remember. He did because maybe, you know, I have a lot of clients through the years, and this was 23 years ago, it wasn't even my client. He remembered. It looked much different, I think, but he remembered that it was me. The judge said, I am not going to kick Mr. Giacino off the case. That's what the DA wanted. The judge says there's no evidence that Mr. Giacino is going to use any information, I said I wasn't, against him, that Mr. Giacino even remembers him and has nothing to do with the case. Now, if it was a situation where I was going to use what I knew against him, and it wasn't even that kind of case, but let's say I could say, well, 23 years ago, you were charged with a crime involving whatever. I couldn't do that. So if I was going to do that, I'd have to get off the case. And the case was already halfway done. Now, would there have been a different result if before the case started? Maybe, maybe not. But I was allowed to stay on that case. I've had jury cases where people on the panel, other than that health teacher, knew me. And of course, they were removed from the case because you don't even want the appearance of an impropriety. Just like if one of the potential witnesses knows the judge. Let's say it's a neighbor of the judge. They're going to say, we don't need this. You're off. Nothing bad about the person they're kicking off the panel, just the appearance of an impropriety. You want that person to get a fair shake. You don't want there to be any, like let's say the judge says something and the neighbor of the judge feels compelled, oh, I got to come back with a guilty verdict. You don't, or not guilty verdict. You don't want that. Okay? Picking a jury is extremely, extremely important because the people that are selected will decide your client's fate. Plain and simple. I think I do a pretty good job when I pick a jury. When you're done, you can always second guess yourself. Maybe I should have got rid of that guy. Maybe I should have got rid of that lady. You don't always know. Right? For instance, I had a trial one time. It was a domestic violence case involving an order of protection. And one of the potential jurors was a cop. And I was getting close to running out of preemptory. And I said, you know what? I have a decent feel about this guy. Let me go with him. And I did. I got a not guilty verdict. It turned out to be okay. Right? Now, after a jury trial, the judge will say to the jury, do you want to stick around and talk to the prosecutor and the defense attorney? They don't have to. They can make a beeline for the door. Some of them stay behind, and I like to talk to them if I get the chance. Because I want to see what was in their minds. Because, look, if I could have done something better, even if I win the case, sometimes they could say, and I usually don't hear this, but you could have done this differently. You could have done that differently. One time I had a civil trial out in Riverhead, and it wasn't a criminal trial. And at the end of the trial, it was a defendant's verdict. It was a tough case. Defendant's verdict means the defendant won. I had the plaintiff. So we go in the back, and that case, we had all female jurors. So we go in the back, and the judge said, this is Mr. Giacino, you remember him. He brought us in separately. He didn't bring the prosecutor at the same time. I'm sorry, prosecutor, the defense attorney. So he brought me in. And they said, do you want to have anything to say to Mr. Giacino? One lady said I liked his ties, which I thought was funny. And then the youngest on the jury panel was like this 19-year-old girl or whatever. I think she was a student at Suffolk Community College. And I'll never forget what she said. She said, I thought you put on a good case, but you didn't prove your case beyond a reasonable doubt. I'll never forget those words. I look at the judge, he looks at me, and he's like, oh boy. And before I had a chance to say anything, he said to her, you understand that the burden of proof is not beyond a reasonable doubt. Right? Preponderance of the evidence in that civil case. As opposed, in some cases, it's a different burden, clear and convincing, but in a civil case, it was preponderance of the evidence. So a little more likely. Beyond a reasonable doubt is a very, very high burden that you find in criminal cases. Beyond a reasonable doubt. Not beyond a shadow of a doubt or any doubt, but a reasonable doubt, a doubt which they have reason to come to that conclusion. She was holding me, and I don't know how the judge kind of ushered me out of there because he knew I probably could appeal the case and get the case back on. And I discussed with my client, we decided not to. But for her to say that, she was holding me to a higher burden of proof, which is ridiculous. Right? So in a jury, criminal jury, the judge will go over those kinds of things. And the other judge did that as well. I guess that girl wasn't paying attention. I wonder how the deliberations went. I never got a good answer. Maybe they all thought it was beyond a reasonable doubt. In that case, I had no chance. But that's just an example of where a juror made a mistake. Now, in a criminal case, let's say a juror says something that shows that there was an impropriety during the deliberations. Let's say, and the jury's told, don't go near the scene of the crime, don't read about it, don't do anything that has to do with that case. Let's say a juror says, you know what, I know that the crime happened in Stony Brook University, and I went there, I drove by it, the lighting was horrible. I don't know how this guy could, you can't do that. If you do that, you can be kicked off the panel. And that's happened. I've seen that happen where somebody does something they're not supposed to do. Or someone hears about it. I've had a few cases in my day that, let's say, made the papers. There's an article about a case. Juror reads the article, not supposed to do that. Comes to the court and infects the jury panel and says to them, you know, I read this article about this case, and we weren't told this, but this guy has a bad criminal record. He's been arrested before. That whole panel has to go. And that would be a mistrial. And so that panel has to go, and a new panel can be impaneled, or the guy potentially could walk. There's double jeopardy rules that apply. But if it's misconduct, usually there would have to be a new panel. Just like you heard of trials, mob trials in the past, where they got to a juror. They either paid him off or they intimidated him. And that juror held out. Now, even if he didn't convince the jury to go not guilty, they couldn't get a guilty verdict because it has to be unanimous, the jury in a criminal case. You can't have 5-1. There's talk about trying to do that in certain states, maybe even New York, but right now it has to be unanimous either way. If it's 5-1 for an acquittal, you can't have an acquittal, all right? You have to keep going. Now, the judge will read them the law and says, keep going. You're in the best position to make this decision. Keep going. And at some point, the judge would have to declare a mistrial and have to do it all over again. Judges don't like to do that. There's an expense, there's time, a lot of wasted time. Think about it. Let's say it's a week-long jury trial and they can't come to a verdict. They got to do this again. What makes everyone think that the next jury is going to get it right? Like in the Magano trial, there was a hung jury, and then eventually there were convictions. It took another jury, which is interesting because everything's out of the bag. So you have less surprises in the second time around. You know what the juries are going to, you know what the witnesses are going to say. I had an interesting jury trial years ago. One of my first, actually my first in private practice. So I left the DA's office, I went to a firm, and I started doing their criminal cases, and it was a felony. It was my first felony. And back then, you could request the jury be sequestered, meaning they don't go home. They go to a hotel, and you can't do that now. It's rare to have that done, like in certain kinds of maybe mob-related cases or whatever, but you really can't do that now. There's an expense involved. But I was in my 20s, and I said, I want the jury sequestered. It wasn't a big, high-profile case. It might have made like one of the small newspapers. And it had to do with taking money from a bank, and it was a 12-panel jury. So the jury was sequestered. We're like the fourth day into the trial. No verdict. They're going back and forth. They're yelling at each other, arguing. Somebody had to bring medicine for one of them, and he wanted to see his wife. You're not allowed to do that. So you're like in jail for 4 days. It was 4.5. It came out to 4.5 days. And the prosecutor, was his last case before he went into private practice. He came to me. He said, "Look," he said, "why don't we? It may be hung. Why don't we come up with a deal?" My guy was a PFO, meaning prior felony offender, which means he would do more time. I'll give him a better deal. Would you take it? I said, I don't know. I'll talk to my guy. He said, let me think about it. He said, I would take it, because he knew if he's convicted, he's going away for a lot of years. If he takes the plea, he'll be out in a relatively short period of time. So we go in the back, and it was Judge McInerney. I believe he's deceased, and he's certainly long retired. And he said, he was very crotchety kind of guy. And he said, we have a jury waiting to come back with a verdict, blah, blah, blah. I said, Judge, the prosecutor came to me and he's made the following offer, and my client would be willing to accept it. And he says, no. He says, we're going to finish this trial. We're not going to do that. And Mr. Giacino, something to the effect that, are you so naive that you think your client is not guilty or innocent? He might have used the word innocent. And I said, Judge, that's not for me to decide. I have a job to do. I'm representing a client. If you don't want to give us the deal, we'll wait. Half a day later, this was Friday, it was in June, it was a warm day, I still remember it. The jury got the call, and they had readbacks and all of that. So you're always on edge. There's not much you can do. This was even before cell phones. So you had beepers. So you couldn't really go too far. You had to stick around because at any moment they might say, we want a readback. A readback would be, we want to hear that witness again. So the court reporter comes out and says, what part of it? Oh, when he was talking about this or that. And you go into it, and you get the readback. Or can we see that piece of evidence? Can we get this? Can we get that? Can you read us back what beyond a reasonable doubt means, or the law, or whatever? When you hear that, you don't know what to make of it. And the jury came back with a not guilty verdict. My client won. Should have saw the look on the judge's face when it came out, because he could have got at least 3 years out of my guy. My guy walks. In that particular case, we found out later that the original vote was 10-2 for an acquittal. 2 of the jurors held out. They wanted a guilty. And that's why they were going back and forth, and the 10 couldn't convince the 2 that they should say not guilty, and the 2 couldn't convince the 10 that they should say guilty. What I found out happened was one of the guys said, I've had enough. I'm going to vote for guilty. The lone holdout had tickets to Hawaii, and like a day or 2 after that, and he probably said, it's 11-1, the heck with it, I vote not guilty. So my guy got a not guilty verdict. The funny part of this story is that before the verdict came out, my client, and he was out of custody, he was allowed to walk around, and when it came time, and this was late in the day, I think it was even after 5, it was a ghost town. It was a Friday, except the court officers involved in this case, and some at the Megs, the front security. And we got a note, and it says there's a verdict. So he said, get your client. So I'm looking for my client, and I don't see him. Now my guy is a massive guy, very, very big guy. I couldn't find him. I look out the window, and I could see his car. He had this really nice sports car. But I didn't see him. So I'm looking, I'm running around, I'm starting to sweat. It's a warm day, I'm outside looking for him, back and forth. I think, where the heck did he go? I'm in the restrooms, I'm looking all over the place. And there really wasn't many people in the building to even ask, did you see so-and-so? So I'm getting real worried now. I don't know what to do. The court officer came up to me and said, Phil, you better get your guy. Couldn't find him. So the judge calls us in and says, where's your guy? I said, I don't know, his car's here. He didn't probably go too far. You better get your guy here, because even if he's found not guilty, I'm going to hold him in contempt. Where is your client? The jury wants to get the heck out of here. People are getting overtime. It was like after 5. So, that's why they wanted to go late as possible, because they were sequestered. They didn't want to go back to the hotel, because we're not going to go Saturday or Sunday. So they wanted a verdict. I go outside. Like I said, it's a warm June day. I think it was like 15th, 16th. And I'm looking at his car. It's tinted windows. And I'm like, I don't know where this guy is. All of a sudden, his seat pops up. He was laying down, sleeping or taking a nap in his car. And he popped up, and I see him, and I'm like, let's go. We're running through the halls. Like O.J. Simpson in that commercial. He's running through the airport. We're running. I'm out of breath. We get in there, and the jury comes out, and it's very suspenseful. It's very stressful for the attorneys and, of course, the defendant. And maybe the victim, although the victim wasn't there. And the jury foreman is asked, have you reached a verdict? And I think it was a female. And she said, yes, we have. What is your verdict? And she came back, and there were 4 counts. Not guilty. Now, you got to be careful, because the first count can be not guilty, and the next 3 are guilty. Not guilty, not guilty, not guilty, not guilty. The DA says, let's poll the jury. You always poll the jury if you lose, because you want to make sure they're all going to say not guilty. So like, let's say it was guilty. I'd say poll the jury, Because let's say, juror number 1, is that your verdict? Yes. Juror number 2, they go all the way through. Juror number 10, is that your verdict? No, I said not guilty. So you have nothing to lose by saying poll the jury. You don't poll it if you win. Another funny thing happened during that case. The allegation was money taken from a bank. Not an armed robbery or anything like that, but more like larceny by trick. And they got some money that was earmarked for somebody else. So a witness was the guy, an older fella, that drove the van around picking up checks at banks. Not cash. This was not an armored truck. Cash, checks were stolen that were negotiated, that belonged to somebody else. So, and he was made whole. So it was really an insurance company that was out the money. But it was still a felony if he did it. So I'm questioning the guy that drives the van around to pick up the checks, because the DA called him. I'm really not sure why the DA called him, but I think it was to say that, the checks weren't lost. They had to have been stolen or taken from him, right? So, and they couldn't really put my guy at the scene, so I wanted to have a little fun with the guy. So I said to him, did you see my client walking around? I knew the answer ahead of time. Walking around your van. And my guy, you can't miss. Like I said, he's a very, very large man, a powerlifter. And he said, no. And I don't know why I thought to ask this next question, but I did. I said, do you know who my client is? No. He said, no. I said, do you know his name? And with that, he said, I'm not even going to say the name because it's similar to what my client's name is, but it was the name of a singer from the 60s. Similar name to mine, but not the same name. So he said that name. The jury starts to laugh. People in the courtroom laugh. Judge got ticked. Order, order. I almost started to laugh. And I said, I repeated the name. I said, that's his name? He said, I don't know. That's what the prosecutor told me. I don't know. I don't know anything. The guy fell apart on the stand by me asking a very simple question. So sometimes you don't know what you're going to get out of a question until you ask it. Sometimes you got to be careful. And he could have said no. But I had nothing to lose by asking that question. The worst that can happen is, I don't know who your guy is. Okay, good. You didn't see him near the van. You can't say he reached in and stole the checks. I did ask him. I said, do you always lock it? He said, usually. I said, could you recall if you locked it on that day? He said, no. Which means that it could have been a number of people on his route that could have reached in, took the checks. Because don't forget, it wasn't like maximum security. These were checks. Who thinks people are going to steal the checks as opposed to cash, which would have 2 armed guards, and they would be very careful, and it's an armored car, not a minivan or kind of a van that he was driving. So sometimes you never know what you're going to get until you ask the question, and you never know how a jury is going to react. Right? Because I may believe one thing and the jury believes another. That's why I like to talk to the jury, because I get a sense of if what I'm saying was credible. If I lost, I haven't lost a jury trial in quite a while, but in an old loss, I might say, why did you find the client guilty? My client guilty? Well, we didn't believe him. We thought that the complaining witness was very credible. That's hard to overcome. If the complaining witness is very believable and your witness is not as believable, you got a problem, right? And you always have to know, I always study the jury because I want to know the jury that's selected. Like if it's all women, I might say something a little bit differently. I don't mean to be sexist, but something may resonate better with, let's say, an all-female jury than an all-male jury or a jury of 5 males or something like that. Right? So you always have to know the expression, you have to know your audience. If you don't know your audience, you can get hurt. If you get hurt, your client could lose and be convicted. So that's it with juries. Now, to stay with the criminal law theme, I want to touch on frequently asked legal questions, criminal legal questions. Because I'm in the courts every day, and people come up to me and they say, what does that mean? Or if I get an attorney, will I be able to beat the rap? They ask me all kinds of questions. So I've compiled some through the years, and these are some of the questions they ask. What do I do if I'm arrested? Very general question. I always say, be a gentleman or be a lady, be polite. Don't be a smart ass. Don't say, you're not going to keep me in here, cop, or you, like I was watching Scarface the other day. And when Tony Montana was arrested, he said, "I have the best lawyer in Miami, and you're going to be working in Alaska." Not a smart thing to say. Even if you had the best attorney in Miami, you wouldn't say that because the police get a little ticked off at that. Right? So don't volunteer any information. You can't. You have to give your name. You have to give, it's like name, rank, and serial number. Give those items up. Name, address, telephone number maybe. If you're arrested, I wouldn't even let them go through your phone because you never know what they're going to find. If you have to turn yourself in, because sometimes my client calls me, or not even a client, but somebody calls and says, they want me to surrender to the 6th precinct. What do I do? So once they hire me, I say, we're going to set up a surrender. I try to do it in the morning so you don't spend the night in jail. Sometimes we don't have that luxury. Because if it's like domestic violence, they usually got to get you right away because they don't want to let you sleep home and then in the morning you kill somebody and they get in trouble. So domestic violence cases, they usually don't give you that option. If it's, let's say, oh, you illegally used a credit card, all right, you can turn yourself in the morning. If you're going to do that, don't take your phone because they can go through your phone. Even if you say, no, I've seen it happen. They can go through your phone and they might find something in there that could hurt you. And don't forget, when I first get a case, I don't know if my client's telling me the truth. I don't know. Did you do that? No, I didn't. And later on I find out they did. And in their phone is a photograph of that credit card. I don't want to hand the prosecution a conviction. So I say, leave your phone home. They'll let you call home if you have to. And from court, you could borrow somebody's phone, call or get a ride. Don't bring your phone. So be polite. Don't volunteer questions. If anything, say, my attorney told me not to answer these questions. That may be true or not, but that's what you say. And you'll do better. You don't want to get into a jam while you're in custody. Get out of custody, get an attorney, and then fight another day. That's my advice on that issue. What's the difference between a felony, misdemeanor, and violation? I talked a little bit about that before. Felony is the most serious. Those are your murders, your rapes, your more serious larcenies where you steal more than $1,000. You use a weapon, a large quantity of drugs, selling drugs, a year or more in jail. Misdemeanor is your run-of-the-mill, could be assault third, could be a DWI. It could be petty larceny where you steal property less than $1,000. Okay? Those are called misdemeanors. They're punishable by up to a year in jail, not more than a year in jail. Now, of course, you could be charged with a felony and misdemeanor, but that's what those two charges are. A violation is the least. A violation could be like a traffic ticket. Or let's say you get into an argument and you push somebody. That could be harassment. You threaten them on the phone, aggravated harassment. Those are not serious crimes. They're not crimes. They're not serious charges. They could, believe it or not, you could still get up to 15 days in jail for a violation. I've never seen that happen. You'd have to be like Charles Manson level criminal and then get in trouble for a violation and then you say, you know what, we're throwing a book at you. But otherwise, it's usually a fine. Misdemeanors could be probation a lot or could be some jail time, and a felony could be probation or 5 years, misdemeanors 3. Could be more if it's a sex offense, it could be 10, like that. The theme is get a good attorney that you can talk to. I've been doing this a long, long time, so I have the answers to these questions. Next question. What is the difference between probation and parole? Probation is, let's say you take a plea to a misdemeanor and they say 3 years probation, or felony, 5 years probation. We have a probation officer, and you have to report to that probation officer. And they can come to your house and they could say, pee in this cup to see if you're drunk or if you're on drugs. If you violate probation, you can go to jail for up to what you could have gotten the first time around. Sometimes they'll cut you some slack. They'll say, okay, you tested positive for pot, we're not going to put you in jail, but we're going to add bad time. So you've been on probation 3 months, we're going to start over again. You're going to lose credit for your good time. Parole is where you've served a jail sentence. So let's say you get 10 years parole, and you've served 8. You're going to be on parole for a couple of years. You have a parole officer, like a probation officer. Very, very similar. A parole is when you get out of jail. Probation is usually to avoid jail, where you can get a mixed sentence, like a 6 and 5. 6 months in jail, 5 years probation, something like that. Do I have to speak to the police? Very, very important question. The answer is no, you don't, other than, like I said, you have to give them your name and things like that. You don't have to. You could say, I remain silent. I don't want to. And don't do it in a wise guy way. Don't say, I'm not saying anything, or I'm lawyering up. Or I've seen these attorneys and they say, shut the F up. You know, don't be a wise guy. Just say, I don't feel comfortable speaking, or my attorney told me not to talk about the case. That is your best bet. Because if you start talking, they're going to take that all down. It can be used against you, or it can be misinterpreted, or it can be twisted around. Don't give a statement to the police. Even if you got an airtight alibi, you can always bring that up later. Because it's not like you're going to say, well, I was in Florida when that happened. Okay, we'll let you go. No. If you have an alibi, your attorney will bring forth that alibi at the appropriate time. What is an arraignment? An arraignment is the first time the case is on when you enter a plea of not guilty. Even if you want to plead guilty, the judge will say, I'm not taking a guilty plea. Enter plea of not guilty, get yourself an attorney. So it's an arraignment. Bail can be addressed at an arraignment. So you could say, I plead not guilty, and the DA could say, we want $50,000 bail. That's a serious crime. Or we want $500 bail, or no bail. That's up to the judge. And if he hits you with bail, you got to post a bail. It could be a bond, where you put your house up, or some real estate. Or if it's 500, you run to the bank, get 500, you post a bail, you get out. The judge considers a number of factors when we're talking about an arraignment and bail. When you come into court, whether you're brought in by a precinct or whether you come from Riverhead or Yaphank or something like that, they're going to do an ROR score, released on your own recognizance score, 0 to 11. If you score 0, 1, 2, 3, 4, you're probably not getting bail, or bail will be very high. If you score 8, 9, 10, you got a better chance of getting out without having to post bail or lower bail. And they look at a number of factors. If you're an illegal alien from some, faraway country, you're probably not going to get bailed out. Or the bail could be, well, ICE probably could swoop in, unless it's a sanctuary city. ICE could swoop in and take you into custody. But let's say you're legally here, but you're from a foreign country that you might go back to if it's a serious crime. The bail might be very high. Or let's say you have a warrant history. You have a habit of not coming back to court. The judge could hit you with high bail. Or you have no ties to the community. You're from California, you're here on vacation. You might not come back. So that could be high bail. But if you're gainfully employed here, you own a house, let's say, you live with your family, you have kids here, the judge is like, he's not going to flee for this particular charge. So maybe 500 bail to make sure he comes back. But a good attorney will use that score to his advantage. Like I've had cases where I look at the score and it's a 7. And some attorneys might say, well, he scores a 7. I look at it and I see that he didn't get proper credit because they couldn't verify something. I might say, Judge, he would have really scored a 9. He's been working for more than a year, or he lives with his kids. They called his house, they couldn't verify it. It should be a 9. I'm doing all I can to get a better score to have my client get out either with no bail or little bail. But that's called the ROR score. And the sheets are pink. So when your client is ready to be called, they usually give that to legal aid, and the legal aid will say to the private attorneys, who has Joe Johnson? Okay, that's your guy, here you go. And then I look at it, and we go from there. Next question. What is an indictment? There are a number of ways that somebody can be charged with a crime. Remember, felonies, misdemeanors. Misdemeanors, you don't have an indictment. You have a misdemeanor information that's sworn out by the police, the prosecutor, and they charge you, let's say, with a DWI, or assault third, or petty larceny. With a felony, the only 2 ways to charge you with the felony, what they call a superior court information. That's usually where the defendant agrees to plead guilty to something, and instead of having the case presented to a grand jury, they sign a document, superior court information. The judge can then prosecute you, which is a plea worked out. With an indictment, it's they present the case to either 16 to 23 people. It's called a grand jury. It's different than a smaller petit jury, or a jury you'd see like in a felony case or a misdemeanor case. This is a grand jury. They hear many cases throughout the day. The defense attorneys are not in there. The defendants are usually not in there. And the expression is you can indict a ham sandwich. The prosecutor presents the case. The grand jury usually only hears one side of the case. A grand jury is a tool of the prosecutor. Right? You can have an indictment not returned. A lot of times it's because the prosecutor doesn't want it. Let's say it's a cop and they don't want this cop indicted. They can make it so that the jury is going to probably say, this cop, I sound cynical, but there's not enough evidence, we're not going to indict this particular individual. But usually, you can indict a ham sandwich. So once there's an indictment, then the case goes before a felony judge, if it's not there already, and the case will be handled, and you are indicted. You're charged. You're not convicted, because it's not necessarily beyond a reasonable doubt yet, but you would then have to face a judge and they go from there. Either take a plea, go to trial, jury trial, bench trial. We talked about that earlier. What is the difference between burglary and robbery? I get that question often. And I like to play games with young people. I'll say, what's a burglary? What's a robbery? People sometimes use these words incorrectly. Like someone might say, someone broke into my house last night. I was robbed. No. If you weren't home, you were burglarized. Robbery is taking something of value from a person with the force or the threat of force. So if you walk up to somebody and you put a gun to their chest and you say, give me your wallet, and you take their wallet, it's a larceny, of course. It could be grand larceny depending on how much is in the wallet, but it's also a robbery because you used force or the threat of force. It doesn't have to be a weapon. If I walk up to somebody that's half my size and I say, give me a wallet, I'm going to beat you up. That's a burglary. I'm sorry, that's a robbery. Now, what is a burglary? If you go into somebody's house or dwelling, could be their law office, could be a deli, could be any place you can go into. Not a car, but any place. And you take property that doesn't belong to you, and you entered the dwelling with the intent to commit a crime therein, that is a burglary. You can also be charged while you're there, you use force, robbery. While you're there, you steal a watch, larceny. While you're there, you take some guy's checks and you forge them, forgery. There's a whole host of things you can be charged with in addition to the burglary. Now, I'll give you an example where it might trick you a little bit and make you think otherwise. Let's say a guy named Charlie is invited to his friend's house. And Charlie goes to the house to watch the ball game. And while he's there, he sees a watch. And he takes that watch. Can he be charged with burglary? Not according to the facts as I told them. Because he didn't enter the building with the intent to commit a crime therein. Now, that's not to say he can't be charged criminally. He can be charged with a larceny. He stole property that didn't belong to him. If it's worth more than $1,000, it's a felony. If it's worth less, it's called petty larceny. The same as if you walk into a deli and you steal a pack of gum. You never see burglary attached with that. It's petty larceny. Burglary is the more serious type of charge. It's a felony, burglary. So if someone breaks into your house and steals your TV, that's a burglary because they went in with the intent to commit the crime. Now, the example I just told, let's say Charlie goes in, sees the watch, doesn't steal it. Goes home, is invited to another ball game, comes there and says, you know what, if I see that watch again, I'm going to take it. Then it will be a burglary. Sometimes it's hard to prove. But what was his intent when he walked in there? If he's invited to watch a game, it's a little harder. If he broke in when nobody was home and he had a mask on and he took property, that's a burglary. He didn't go in there to watch the Capitals game that's on tonight. He went in there to steal property. One of the questions, and I already answered this earlier, is can I get a jury trial? It's up to the defendant. If it's a misdemeanor felony, the prosecutor has no say. Can't say yes, can't say no. The defense attorney and the defendant decide. Can a felony be reduced to a misdemeanor? Of course it can. That's called plea bargaining. You plea bargain the case away. So if you charge with a felony, your attorney would say, look, he's got no priors, he's a good guy, he's working, he's got a family, let him plead to a misdemeanor so you won't have a serious felony. Of course, I try to get it lower, like a violation. Sometimes you can, because with a misdemeanor or felony, he goes for a job. Have you been convicted of a crime? Yeah, I was convicted of a misdemeanor. Sometimes it's, have you been convicted of a felony? And the answer is no. If it's not a felony, if it's only a misdemeanor, you could still say no, because the question was, was it a crime? Misdemeanor is a crime, but if the question was felony, you don't have to say yes, you say no. How much time can you get for a felony? Remember I said more than a year or more in jail. Misdemeanor is a year or less. Is there restitution in a criminal case? There can be. So let's say you break somebody's window and they didn't have any insurance and they're out $200. Part of the plea deal could be you have to pay the $200, or probation can say you owe $200, you got to pay that money. Or somebody had insurance, but there's a deductible. The deductible is $500, let's say. You damage their car. You could be responsible for paying their $500. We only got about a minute and a half left. I just want to mention, I wrote a book called Divorce, a Practical Guide. I was going to say Finding Common Ground. Divorce, Practical Guide. If you want information about what you should do if you're going through a divorce or family court case, take a look at the book. You can see it through my website, which is jacinolaw.com, or book outlets, Amazon. It's a good read. It is chock full of information, I say from soup to nuts, from the beginning to the end of what you should do, what not to do, to assemble your team, what to look for when you're going to hire an attorney. Very important things. It's only about 100, not even 100 pages. Read it if you get the opportunity, and you will see that some of the things you believe are true, some of the things you might think your best way to go are not true. So before you do that, before you go through a divorce, take a look at the book. I want to thank you for watching. If you like the show, you can also see it on YouTube, probably in about a week or two, and just go to WLINY Internet Radio, and you could see it, you could subscribe to it, and you could see future ones, or you can go to Facebook Live and see Finding Common Ground, like and share. Thank you for watching. You take care.